This is Richard Wagner, Chief Justice of the Supreme Court of Canada, and in a press conference he said that the past doesn't matter anymore. Specifically, he was being asked about a controversy in which the Supreme Court was refusing to translate its pre-1970 decisions into French. How were Francophone lawyers and judges to cite legal precedent if they can't read it? To which Wagner replied that they don't really need precedent, especially from before the 1970s. Sometimes a decision from 5 years ago is an old decision, he said. Which is weird because law is all about precedent. For instance, many Canadian Indigenous rights cases will still cite the Proclamation of 1763, a British mandate establishing native land title in the New World. And if you're not deciding cases based on the collective reasoning of your judicial predecessors, aren't you just making stuff up as you go along? I won't say they are, but we've been getting an awful lot of Supreme Court decisions that veer strongly into the make stuff up category. For instance, multiple cases have been decided based on hypothetical scenarios that never happened. An Alberta man was facing a mandatory 4-year sentence for gun crimes after he randomly fired a hunting rifle at strangers, and his lawyers were arguing that mandatory gun sentences were cruel and unusual punishment. The Supreme Court said, well, what if it wasn't a hunting rifle? What if it was a low-powered air rifle? Then it would be cruel and unusual punishment to lock him up for 4 years. And that's why we don't have mandatory minimum sentences for firing at strangers anymore. Or you keep getting cases litigated based on unwritten principles. This is the notion that even if a law doesn't violate the Charter in any material way, the Supreme Court can strike it down anyway if it violates Canada's unwritten principles, which are hard to define because they're not written down. A Supreme Court decision in 2021 ruled that unwritten laws probably shouldn't take precedent over actual real laws, but it was a 5-4 decision. The dissent ruled that, quote, unwritten constitutional principles may be used to invalidate legislation, unquote. And given that we've had a few staffing changes since then, that view could well win out the next time someone asks the Supreme Court to invalidate an act of Parliament based on some unwritten stuff they thought of.